大家翻嚟啦，咁我哋繼續逐條審議去到第12條嘅，咁時間再繼續交翻俾證監會，唔該。
Thank you, Mr. Chairman. We have found that reference to the broker regulation, which a member was asking about. So I wonder if Mr. C will respond to that.
好，係先生。
頭先就簡議員問到我哋第9條入面嗰個 becoming aware of 嗰個時間點係咪有參考嘅資料？咁就係其實我哋都係參照翻即係證券期貨 financial resources rules， 即係第571N 章入面咧，係就住 license corps， 即係我哋平時叫 brokers 嗰啲相應嘅 financial resources 嘅 requirement 入面第55條，佢而家就住一啲類似嘅規定，即係譬如話佢個 liquid capital falls below 120% of its required liquid capital 嘅時候咧，都有一個同等嘅時間性，就係第一就係 as soon as reasonably practicable。咁但係就如果你一知道嘅話咧，你就要喺1個工作天內。咁我諗呢個真係兩把尺嚟，即係第一就係你其實嗰個準則係 as soon as reasonably practicable。咁但係咧就多一個額外情況，你一知道嘅話咧，我就要你1個工作天咯。即係我諗呢個係嗰個理念咯。
好，江玉歡議員。
主席啊，我想問咧11嘅主席。我想請咧，即係可唔可以即係同事都解釋一下咧？就係嗱，你而家喺11嘅2嗰度咧，就嗰啲 ASR 咧保存文件就唔能夠少於7年。但係咧喺我哋頭先審議完嗰條咧，講關於即係呢個即係LN 15嘅時候咧，呢一個嗰個 uncertificated securities market 嘅 rule 咧，關於 issuer 咧，佢去到 keep register holder。兩樣嘢嚟嘅，我知道佢哋咧就要唔少過10年。我想問咧，其實可唔可以解釋一下俾我哋聽，點解一個你就會可以 keep 7年嘅嘢，一個譬如 issuer 講 register 嘅時候就10年？其實你嗰個你哋嗰個原則係啲咩咧？可唔可以解釋少少？
係證監會嚇。
Yeah, so thank you for that question. So the 10-year requirement on issuers is really for alignment with the CO. That obligation is imposed on the issuer. The obligations here under Rule 11 are imposed on the ASR, and it doesn't seem correct to impose a harsher requirement on ASRs to cover all of their records to 10 years. I mean, there doesn't seem to be a real need to do that. In reality, if the share registrar is keeping the ROM, they will keep it for 10 years because that's the obligation under the CO. There's also the possibility that the share registrar might change. The issuer might change its share registrar over time. So there's no need to align the two, is the way we see it.
好，下一位簡慧敏議員。
係，多謝主席。多謝局方律政司引述翻嗰個出處啦。我諗即係都係嗰句啦，即係交翻俾 SFC 同埋即係 FSDB 局方去考慮下。即係我喺審議另一條條例都係㗎啦，即係都係嗰句嚇。究竟我哋衡量緊嘅係咪同樣嘅風險啦？因為你如果類比license corp 咧，啲交易商咧相對而言係多好多間啦，咁所以佢個風險係分散一啲啦。但係如果你淨係講 registrar 嘅話，即係 registrar 可能會都係集中嗰2-3個咁樣，咁係唔係用同樣嗰個標準咯？嚇，我都係想即係記錄翻呢個我哋考慮過嚇。唔該。
使唔使作出回應？其實 OK 好，證監會可以繼續。
Moving then to clause 12. So clause 12 talks about the manner in which records are to be kept. So key is that they must be kept in a way that enables an audit to be conveniently and properly carried out. And where applicable, entries must be made in accordance with generally accepted accounting principles. Clause 13 deals with the falsification, destruction of records, and it makes it an offense to, with intent to defraud, enter information which is false, delete, destroy, or remove or falsify information, or to fail to enter or record or store such an information. And penalty levels are stipulated in subclause 2. Moving then to part 5, which is the audit and reporting requirements. Clause 14 requires that the ASR must appoint an auditor, and it must do so within 1 month after certain events. An approved securities registrar must also, within 7 days of appointing it, notify the SFC of the auditor's details. Subclause 3 notes that within 1 business day after each of certain events, the ASR must also notify the Commission in writing of that event. And the events are that it gives notice to its members of a motion to remove an auditor or replace an auditor, or that an auditor that has been appointed ceases to be its auditor before the term of office expires. Clause 15 relates to the approval regarding a ASR's financial year. So subclause 15.1 requires that the ASR cannot change its financial year without the SFC's approval. Subclause 2 deals with the Commission's approval powers. Clause 16 deals with the audited financial statements of an ASR and requires that these must be submitted to the Commission within 4 months of the last day of the financial year, the ASR's financial year. Subclause 2 notes that the ASR must cease to provide securities services registrar services, or rather, an ASR that ceases to provide securities registrar services must, within 4 months of ceasing, submit financial statements that are prepared up to that period. Subclause 3 provides that the ASR must submit, together with financial statements, the auditor's report. Subclause 4 provides that the ASR must also submit its total capital expenses projected for the 12 months to come and a description of its plans to finance expenses. Clause 17 deals with periodic returns. There are 2 returns that we require. One is a quarterly one, which is relating to the ASR's financial status, and one is an operational one, which is to be provided on a half-yearly basis. Subclauses 2 and 3 list out the information to be included in those reports. Clause 18 deals with reportable matters. So these are matters relating to the ASR's service facilities or operations, and that need to be notified to the SFC immediately. And after notifying immediately, the ASR also needs to submit a written report regarding the entire incident. Clause 19 relates to notification of changes.
我哋等一等，江玉歡議員。
何嘅呢一啲事件向 Commission 匯報咗之後，請問 Commission 會唔會第一時間知會公眾嘅呢？想請問。
Thank you for the question. I think that really depends on the particular event or incident in question. If it calls for some more public notification, then we would do it, but if it doesn't, then we wouldn't. It has to be a case-by-case assessment.
譚國強議員。
谢谢，就是我翻到前面第17条啊，第17条这个按照季度，同时又要求按照半年，实际上这个半年就包括了季度，为什么一定要重复的报一次呢？因为3、6、9、12， 6呢是半年，但实际上又是第2季度。所以你要报第2季度，还要报个半年，你或者是我们都是就是按季，就是4个季度。我记得上市公司，有的就是像 A 股市场，它就是季度，按季度这个业绩。我们香港呢是半年，香港的上市公司是半年报一次，并没有说季度报一次。这里为什么是要按季度又要按半年呢？
Thank you for that question. So the quarterly requirement only relates to the ASR's financial status. So if we see that subclause 1A talks about the information specified in subrule 2, and subrule 2 relates to the financial status of the ASR. So its available liquidity, its total operating expenses, its minimum liquidity level, its total equity, and its external borrowings. The half-yearly report, which is referred to in subclause 1B, refers to reports on its operational matters. And it will be seen that in subclause B refers to the information contained in subrule 3. And if we look at subrule 3, the matters that need to be clarified are matters relating to their issuer clients and security holders, activities through their facilities, inquiries and complaints received, service facility incidents, operational incidents, and cases where the registration of a transfer was refused. So they are, the two reports, the contents of the two reports are different.
OK， 好，下一位簡慧敏議員。
主席，嗱，我諗呢度咧第17條嗰度咧，可以同我哋詳細少少睇下嗰個營運事故同埋嗰個服務設施事故個內容啊，佢個出處係點樣咧？又參考咗啲乜嘢嘅咧？同埋營運事故同嗰個服務設施事故有乜嘢主要嘅分別嚇？即係點解你要即係營運事故，仲要加個服務設施事故，都係即係需要通報嘅事項嚟嘅。咁亦都通報事項嗰度咧，即係喺第3條嗰度嚇，即係 Subrule 3咧，就有提到話如果有關嘅事故嘅不利影響，如果係技術性同埋咧係容易迅速地糾正咧，就除外，就唔使通報嘅咁樣。咁呢一個又係點樣定咧？係嗰個 ASR 自己主觀地認為呢個技術性嘅啫，我唔使話你聽啦咁樣。點樣樣咧？嚇，唔該。係
不同類型事故嚇，證監會。或者梁生。
簡議員或者我解釋一下，其實呢度咧就只係要求佢哋喺個每半年嘅記錄嗰度咧，將嗰啲事故咧係再詳細列翻出嚟啦。但係其實如果發生事故嘅時候咧，其實我哋要求咧會要求嗰啲核准證券登記公司咧馬上要通知我哋，因為咧嗰啲事故有好似你話有大中小嘅影響嘅。如果啲影響係好嚴重咧，我唔會等到半年先至通知我嘅，佢要即刻就通知我哋。咁呢個其實都有啲似咧，我哋而家監管香港交易所都係嘅。香港交易所咧，佢營運好多系統，佢提供好多服務。咁如果喺佢營運系統同埋提供服務嘅過程有啲事故嘅時候，咁我哋都會同佢講清楚乜嘢係叫做小型啲嘅，你唔需要立即通知我哋。有啲係要立即通知嘅。咁所以呢度咧，只不過係一個報告，佢要用一個書面報告再記錄翻佢之前發生嘅事。但係如果發生一啲嚴重事件嘅時候咧，佢要馬上通知我哋。
係主席，呢度係答咗18條啦嚇，第18條就係馬上通知嗰度啦。但係啲定義放咗喺第17條，主席嚇，即係由於又係嗰個定義放咗喺第17條，咁所以睇18條嘅時候咧，就係當睇邊啲事故係需報告嘅咧，就指向翻去17.6啦。咁所以我哋都要參考即係17條嗰啲嘅定義嘅。咁所以我想聽聽嘅我問題嘅另一部分就係話呢啲事故我哋點解除咗營運事故就仲要服務設施事故咧？咁樣嚇，我哋可以藉呢個時間討論第18條啦。唔該。
可以。
So thank you for that question. So the distinction between service facility, the reason we have two types of incidents is because operational incidents may not necessarily relate to an service facility or system matter. So for example, an obvious one would be if the premises are flooded, or if there's a fire, or if for whatever reason the premises cannot be entered into where there are counter services. So we would want to be informed of that immediately. Service facilities, I think, is perhaps more self-explanatory. It's really relating to systems, their computer systems and facilities.
好，冇其他跟進嘛？
或者解一解嗰個 service facilities 嗰度嘅字眼啦，呢度都有提到話係即係除咗一啲冇計劃嘅中斷，而或者係持續醖釀的事件咁樣嚇，即係呢度係點樣理解咧？英文就用 emerging event， 同埋我嘅問題嘅問得太多，可能喺裏邊嘅內容一次過亦都有提到除外嘅就係技術性嘅就除外，或者呢度有提到 easily and promptly rectified 嘅就唔使通知咁樣，係呢個係點樣解讀啊
？Perhaps it's worth mentioning that we do classify these incidents in 3 categories and expand on it in the ASR code. The reason we include emerging events is because if they become aware of something that may lead to a disruption, then the awareness of that initial emerging event is enough to trigger notification to us. They shouldn't be waiting till their systems have really been affected before they notify it to us. That's the reason for covering emerging event. The reference to unplanned interruption is really the broadest sort of description that we can try and cover. The whole idea of the service facility incident is basically that something has happened which was not intended to happen and which is potentially going to cause a problem. So with that in mind is how we have defined this definition. The paragraph B perhaps, or A and B, sort of expands on what the impact of that incident needs to be. So for example, it will affect the normal functioning. This is important because it will potentially affect investors. So for example, maybe they can't deposit their shares into CCAS. The availability, security, confidentiality, authenticity, and integrity of various transactions and communications, I think that's pretty self-explanatory, that obviously these things are of utmost importance to investors. So if there's anything that threatens these matters, then these are things that we consider important that need to be notified to us.
而技術上嘅就係除外，純粹一個技術上嘅問題係咪啊？技術性嘅問題就唔使通知啦。但係有個並嘅嚇，你有個技術性並可容易及迅速地糾正嘅就除外。
Yes, that's correct.
而呢個就係即係事實上啦，係咪？所以唔需要講係邊一個嘅人嘅角度去睇，即係唔一定係個 ASR 嘅 opinion。
That's correct, yes.
好，唔該。
Thank you.
可以繼續啊，證監會。
Moving then to clause 19.
19係可以。
That's the notification of change. So we have a list of matters set out in Part 2 of the schedule, and whenever the ASR becomes aware of a change to those matters, it needs to notify the SFC. Subclause 2 talks about the time within which it has to submit that notification. Moving then to Part 6, which is the handling of third-party money. So the requirements under this part essentially require segregation, focus on segregation of third-party monies. So the requirement is that the ASR must establish and maintain segregated accounts, designate if the account is trust account or third-party account. And when there are third-party monies, they must move it into the relevant segregated account within the stipulated time, which is 1 business day. The provision also talks about monies not being removed from this account except as authorized or directed. Clause 22 talks about payment of money out of a segregated account. Subclause 1 talks about the ASR, where an ASR holds amounts, third-party amounts in a segregated account, it must retain it there until it is paid in accordance with the instructions. Clause 23 deals with the reporting of non-compliance. So the requirement is that the ASR must, within 1 business day of becoming aware that it has not complied with either Rule 21 or 22, notify the Commission of that fact in writing.
簡迷問議員。
主席，呢度咧就我想了解嗰個出處啦，因為處理第三者嘅 third party money 係非常之重要啦嚇，即係要有 segregation 啊，分開佢嚟到去處理，唔可以同自己嘅錢嚟到去即係混埋一齊咧，就保障嗰個債券證券嘅持有人啦嚇。咁呢度我想即係參照咗邊一度啦。咁同埋咧，好似我哋一路討論咧個 ASR 要做嘅嘢咧，個罰則都唔係好清楚嘅，即係除咗喺前面有一啲部分講係個 offence 可唔可以帶一帶我哋去睇下 冇做到係點咧？即係呢度嗰個 offence 咧，就喺第13條就有提到 falsification， 即係造假嘅記錄咧，或者係銷毀咗啲記錄咧，就有一個即係 offence creating 嘅，嗰個就係一個有罪行嘅嚇。咁其他嘅部分，如果 ASR 唔跟咁又點咧？我一路等嚇，即係去到呢度第6部分啦，都未見到有嚇。唔該。
Thank you for that question. So the consequence of breaching the ASR rules is not provided in the ASR rules itself. As an SFC approved entity, the SFC will be able to take disciplinary action under Part 9 of the SFO. So the 2021 Amendment Ordinance amended the disciplinaries part in the SFO to cover breaches by ASRs. And so where there is a breach by an ASR, including breaches of the ASR rules, the SFC will have power to take disciplinary action against the ASR, and that is provided under Part 9 of the SFO as amended by the 2021 Amendment Ordinance.
咁主席嚇，我繼續了解下。咁呢個關於佢要 segregation of third-party money 嗰個咧，你嗰個即係嗰啲 disciplinary action 嚇，即係相關嘅紀律嘅行動咧，係有冇刑事嘅咧？足唔足夠咧？即係呢啲如果係純粹係罰嘅話，嗰個第三方嘅損失，即係萬一你進入破產，你又冇將嗰個third party money 去分開嚇，我諗呢一個係對嗰個投資人係一個好重要嘅保障嚟嘅，即係能夠將嗰個資產係獨立存放第三方嘅款項呢一個嘅要求，即係就住呢一點嚇，有冇？
Yeah, thank you for that question. So if it is misappropriation, then that would be theft, and that would come under the theft ordinance. We do not have an offence for breaches of these provisions of Part 6. The offences that we have are really where fraud is involved. For those two provisions in the ASR rules, one which Ms. Can mentioned, let me just dig those two out. There are essentially two offence provisions under the ASR rules, and both relate to fraud and
destruction.
Yeah, but for just breaches of the obligations and requirements, we do not have an offence. We are relying on the disciplinary regime, and the rationale for that is because we think it's a much more effective deterrent. Bearing in mind that securities registrars are entities that want to stay in the business long term, so they will be much more concerned about their reputation and their any potential imposition of restrictions that we may impose on them.
好，咁亦都即係請即係法律顧問都確認一下，即係如果局方所講嘅SFC 所講 misappropriation of money 嗰個嚇，即係如果佢冇按第23條去獨立咗個帳戶嘅話，係唔係構成即係盜竊咧？係咪一個可以用即係相關嘅刑事嚟到去即係規管嗰個 ASR 咧？唔該。
係法律顧問有冇啲咩補充？
係多謝主席嘅。咁我哋都同意證監會頭先嗰個説法嘅。咁因為我哋留意到，其實我哋都留意到簡議員提出嗰個問題啦，亦都之前去詢問過政府當局嘅。咁佢哋解釋翻呢，都係如果係違反咗呢啲嘅要求規定咧，都會係一個一個係一個 disciplinary action 一個紀律行動嘅。咁而就唔會係一個刑事嘅罪行。咁而頭先證監提及到咧，如果係有一啲唔適當去使用一啲金錢 misappropriation of money 咧，咁就會係根據翻即係可能另外一啲法例，例如即係 theft ordinance 嗰啲方法去處理咯。多謝主席。
多謝。
OK，證監會可以繼續。
Thank you, Mr. Chairman. So we move on to Part 7, which is Clause 24 of the ASR rules. So Clause 24 is an obligation on the ASR to send an annual statement to registered holders of their holdings. The idea of this provision is really that in the absence of a certificate or document of title, the investor should at least get an annual statement confirming its holdings with the relevant securities registrar. This obligation is imposed on the ASR rather than the issuer, because the ASR will be operating uncert system through which it can evidence a number of securities. Turning then to Part 8, which sets out the duties.
江玉歡議員。
對唔住啊，主席嚇，我想請問一下24嘅4嗰度咧，就係話嗰個 approve 嘅 register 嗰個 ASR 啦嚇，咁佢咧就可以去 charge 一啲 fees 嘅。如果嗰個人係要 hard copy form，咁呢度就係話咧佢可以去到 charge 個 fee B 嘅2啊，就係 so that 佢係 provide 一個 reasonable disincentive for using paper documents。咁嗱，喂，呢個我就想問啦，會唔嗱呢度又冇限定佢可以最高收幾多錢喎？仲要係俾佢哋可以係有一個係 disincentive 嚇。咁我想請問一下，呢度你哋喺你哋嗰度有冇咩指引呢？嗱，我見到你哋頭先我哋審完嗰條咧，主席啊，咁就嗰個 issuer 咧，去俾翻 copy 啊嚇喺嗰度咧，都有去到即係有一個準則嘅喺嗰度啊，指明費用啊嚇喺頭先嘅 Rule 8嗰度其實。咁想請問呢一度你會唔會都有一個普帽咧嚇？定係咩普帽都冇，仲俾佢哋好似 disincentive， 佢會唔會好貴咧 charge 得
？Thank you for that question. So the whole idea is that it should be a disincentive. So we do not expect it to be cheap. Having said that, there is a general requirement in the ASR code that fees must be reasonable, commensurate, fair in all the circumstances. So while we do expect the fees to be not low, shall we say, we do not expect them to be exorbitant, because if they were exorbitant, they would be in breach of the ASR code.
主席啊，我認為咧，我明白嘅，我哋都唔係鼓勵啲人要主紙張。咁但係你有冇一個，即係你哋譬如做得個 code 嘅時候，你哋都有冇一個最高嘅一啲，即係佢唔可以超過某一個限額嘅數咧？如果唔係，到時一個投資者佢會覺得嗰啲嘢可能都係唔合理嘅喎，係咪嗰個費用？咁我哋點樣處理咧
？Thank you for that question. So the ASR code will be stipulating upper limits for certain fees, but not all fees. The fees that we want to stipulate upper limits for are really fees that relate to services that are regularly used by investors and that directly impact the investor. So the three main ones that we are looking to set upper limits for are the fee for dematerialization, the fee for effecting transfers, and the fee for setting up a USI facility. We do not propose to set upper limits for any of the other fees. We don't see that there is a regulatory need to do so, and that the overarching requirement in the ASR code that fees should be reasonable will suffice. That said, it is always open to an investor to lodge a complaint to us. And if they did lodge a complaint to us and we did feel that the fees were exorbitant, it would be open to us to take action under the disciplinary regime.
主席，點解我咁樣問呢？我唔係想阻辭嘅，我係想指出呢，有時喺法庭嘅程序呢，我哋都係需要紙本嘅。例如我哋譬如喺 mental health 嘅 provisions 裏邊，我哋可能要 satisfy 嗰個 court。OK， 我哋係要譬如去到點樣處理有關嗰個mentally incapacitated person 佢嗰個 affairs， 又或者當我哋去到申請遺產，即係嗰個承辦嘅時候，我哋都係可能要填 schedule， 我哋係要 satisfy 個 court 嘅 requirement 嘅。所以想請問喺呢一度，咁都有時我哋係會問個 ASR 咁啊，譬如當佢去到無紙化嘅時候，咁呢個會唔會出現一個我要好貴咧？我唔係想攞紙張嘅，不過我係需要去攞紙張啊嘛。
Thank you for that question. So again, it's the ASR requirement. The requirement in the ASR code is that the fee must be commensurate to the circumstances. So it would be incumbent on the ASR to take into account all relevant circumstances.
咁江議員講呢一點，主要都係強調即係喺一方面可能唔鼓勵向電子化啦，但係同時亦都唔可以一啲合理當事人應該可以攞到嘅資料，都唔應該即係過度留難佢，因為用一個費用作為一個手段，即係令到佢唔可以行使翻佢嘅權益， 如果佢係攞到一啲紙張，都係一個合理嘅一個權益，咁你儘管貴啲或者點樣，但係就唔應該好似唔應該太過分。
因為主席點解我咁樣咧有擔心咧？因為喺 B 嗰度咧，呢個係 and 啊 ，recovering the cost and providing a reasonable disincentive。咁我覺得，如果我係嗰個 ASR， 咁我 recover 個 cost， 不過個法例寫我係仲要 provide 一個 reasonable disincentive， 所以我有一個咁嘅擔心。我知道佢哋唔會咁樣做，不過我想提出呢樣嘢，請大家即係留意啫，係咪？唔該。
請局方考慮啱啱嘅提議啦，係啦。睇下仲冇其他跟進就再繼續可以。
Okay, thank you for that question. Oh, I don't think that's a question, right? Sorry, I beg your pardon. So we move on to Part 8, which is these are the provisions that deal with where there is a change in the securities registrar. So Clause 25 sets out or requires that the securities registrar or the ASR cannot just cease to act as an issuer's ASR. Any seizing must be with the issuer's consent or with the permission granted by the SFC or for the purposes of avoiding contravention with the requirement under the ordinance. The details in Clause 25, so Subclause 2 goes on to talk about where the Commission may permit the registrar to cease to act as the ASR. Essentially, it is where it is satisfied that it would be impracticable, unreasonable, or unduly burdensome for the registrar to continue acting. Subclause 3 deals with the manner in which the permission is to be given. And Subclause 4 specifies that the ASR is not to be regarded as contravening Subrule 1 if it ceases to act only because the securities are no longer prescribed securities, which means they have ceased to be listed. Clause 26 deals with the duty to transfer records when there is a change of share registrar. So essentially, the idea is that the records should be transferred to the incoming ASR as quickly and as smoothly as possible. So the obligation under Subrule 1 is that the outgoing ASR must take all reasonable steps to complete the transfer before the cessation. And if it is not completed before, then it must be done as soon as practicable afterwards. Subclause 2 talks about the transfer being to the incoming ASR, and if there is no incoming ASR, then it must be to the issuer. Subclause 3 expands on the records that need to be transferred. Subclauses 4 to 7 are relatively procedural matters. Turning then to Clause 27, this relates to the duty to notify the Commission and the exchange when there is a change in the securities registrar. The reason for this provision is just to make sure that the Commission is aware that there is a change and can monitor and make sure that any handover is carried out in an orderly manner. So the provisions require in Subclause 1 that the Commission and exchange be notified. The obligation is on both the incoming and outgoing ASR. Subclause 2 requires that the notification be given at least 3 months before the change. It also specifies what the notification needs to include. Turning then to Part 9, which is the supervision of approved securities registrar. So Clause 28 provides that the Commission may require an ASR to provide the SFC with any information or document that the SFC may reasonably require to perform any function of the SFC. Clause 29 relates to the preparation of reports by a skilled person. The skilled person is someone with technical expertise, which the SFC may lack. And the idea is that the Commission should be able to appoint a skilled person or require the ASR to appoint a skilled person to prepare a report to assist the SFC in its work. Part 10 then deals with miscellaneous provisions. Clause 30 refers to the requirement that ASRs must communicate with the SFC via an electronic transmission system which the SFC has specified. This is essentially to encourage communications between the SFC and the ASR to be electronic as far as possible. Clause 31 is a general power and enabling the SFC to modify or waive any of the ASR's obligations under the ASR rules. And Clause 32 is another offense provision which deals with destruction, concealment, or alteration of accounts or records fraudulently. And breach of such destruction, concealment, or alteration constitutes an offense. Mr. Chairman, that's all for the ASR rules. Sorry, I beg your pardon. Spoke too soon. The schedule. So the schedule is a list of matters that the ASR must notify the SFC on if there are changes. So Clause 1 deals with definitions. Clause 2 deals with basic information relating to various individuals. It includes the persons that they have to provide this information about are also listed. But it's basically their identity information and their address and contact details. Clause 3 sets out some of the relevant information. So this refers to information relating to whether any disciplinary or criminal or judicial processes are underway or relate to them that may sort of impugn their fitness and possibility and propriety and fitness and properness to be related to a ASR.
我哋等等先，江玉歡議員。
主席，我想請問一下關於2嗰個 basic information 嗰度咧，嗱我見到咧1就有關人嘅啦 individual， 2就係有關公司啊嚇。咁喺公司嗰度咧，你就要求佢喺 B 嗰度 boy 嚇，就如果佢有一啲 formal names， 佢係要展述嘅。咁但係點解人嘅時候 formal name 或者佢啲 alias 就唔使展述咧？嗰啲別名或者 formal names， 人同公司有咩分別咧？呢度？
In fact, the application form that we have prepared actually includes former names. May I get back to you on this point? It might be reflected elsewhere.
係，先生。
個補充咧就係呢個附表入面嗰啲資料咧，其實都係好似頭先前面嗰啲條文咁樣，係參照翻現時就住license corporation 嗰個相關嘅規定嘅。咁相關我哋呢個條文咧就係第571S 章證券及期貨發牌及註冊資料規則入面咧，佢而家就住個人同埋法團嗰個基本資料嗰個定義係咁樣，咁我哋都係要維持翻嗰個一致性咯。
但係即係我諗個邏輯理解嘅，但係如果譬如之前錯咁，後邊再繼續錯落，我唔係話係一定錯啊嚇。但係如果係咁嘅話，咁你即係趁而家呢個機會，大家我諗江議員提呢樣嘢都即係有佢嘅道理嘅。即係如果你個人或者你嗰個公司佢都有可能有改名嘅情況，咁儘管可能追蹤翻到去另外一條法例，但係喺而家呢個咁樣嘅情況都要睇下點樣有冇啲優化嘅措施，或者當時除非有更加好嘅解釋，當時條法例係咁樣定咯嚇。
The application form actually doesn't require this piece of information, so changes will be incorporated. Changes in their name will be something that we will require them to provide. Another point to note is that the information that's required to be submitted is not restricted. On application to become an ASR is not restricted. This is covered in the in the amendment ordinance that the SFC can ask for any information that we require at the point of application, and so former names are included.
主席，其實對唔住啊，我想解釋少少啫。點解重要咧？因為咧，其實嗰個人嘅資料咧，係可以俾你哋容易去到跟查，譬如佢有冇啲咩違規嘅事件，或者佢有冇一啲譬如 criminal investigation whatsoever。所以我覺得咧，即係我同意主席頭先講，如果可以嘅話唔緊要，你唔喺條例度，譬如喺個 code 度，我覺得可以講得清楚啲，好嘛？或者喺個申請表度。唔該。
Thank you.
係啦，我諗證監會同埋局方翻到去可以考慮一下啱啱提出呢個問題有冇啲優化嘅空間咁樣，係嘛？可以繼續嚇。哦，唔係或者我而家法律顧問有少少時間交俾你嚇。
係，多謝主席嘅。咁就住呢個附表第2條嗰度咧，基本資料嗰度咧有個補充資料想俾議員參考嘅。咁議員都可能留意到啦，其實我哋而家立法會咧法案委員會咧都係審議緊2024年公司修訂第2號條例草案嘅。咁就會旨在引入一個公司遷冊條例嘅。咁我哋就察悉到啦，如果該條例草案咧獲得通過嘅話咧，呢一個附表嘅第1部嘅第2條咧提述到關於法團嗰度嘅基本資料咧係有可能需要作出相應修訂嘅。咁就此我哋都同翻當局作出咗查詢啦。咁而當局亦都同意咧會喺條例草案嗰度作出相應修訂。咁就加入翻咧關於法團過去啦同埋最新近嘅本籍所在地嘅資料嘅變更嘅。咁我亦都留意到啦，政府當局會喺條例草案嗰度咧就提出委員會階段審議案咧，以便喺公司遷冊條例獲得通過之後咧，咁呢一個法律公告入邊嘅附表嘅相關條文都會作出相應嘅修訂嘅。咁呢個補充資料俾翻議員參考，多謝主席。
好，唔該，法律顧問嚇。局方有冇啲咩其他補充？冇。
法律顧問講得正確嘅，我哋會喺 reform 嗰度，我哋會加翻呢個嘅 CSA 嘅修訂。
OK， 好。證監會可以繼續。
So we then move on to the stock market listing amendment rules. So
個附表一個附表啱啱講到一半係咪？個附表啱啱係未講完。
Sorry, I beg your pardon. So part 2 of the schedule describes the matters where there is a change. Then these matters, they must be notified to the SFC. So it includes change in the basic information of the various people, so the ASR itself, any officer, senior employee, any person with whom the ASR is associated, any director or substantial shareholder, any shadow director, any subsidiary or related corporation. So those are the persons in respect of whom basic information needs to be provided. The schedule goes on to talk about other changes that need to be provided. So item 2 is any change in the persons themselves, so not just the details of the person. So if there's a change in the officer, then that change has to be notified as well. Any change in the contact details, any change in the status of authorization to provide similar services outside of Hong Kong, any change in the status of their membership in any clearinghouse, CSD, exchange, or elsewhere, whether in Hong Kong or elsewhere. Any significant change in their business, any change in their share capital, shareholding structure, any change relating to the fees charged in relation to the provision of securities registrar services, but this focuses on fees charged to investors, not fees charged to issuer clients, and any change in their corporate group structure, any significant change in their service facilities, any change in the information regarding their assets, any change relating to their bank account details, any change relating to their premises or the circumstances of their premises. So, for example, if there's been a big fire and the premises are destroyed, and any change in any insurance coverage that they're required to take out.
係江玉歡議員。
主席，我想請問一下咧，嗱喺嗰個 Part 2嗰度咧，有啲就係any change，有啲就係 significant change。咁我想問 change 同 significant change， 你哋點樣界定嘅咧？亦定係有冇邊一度係可以清晰講個分別喺邊嘅？
Thank you for that question. There isn't a real definition anywhere. It's really, to be honest, a common sense approach. So if we look at some of the provisions which deal with significant change, the first one would be Item 7, which is significant change in the nature of a business. So if there are minor changes, we don't need the share registrar to notify us of everything. It's really significant changes relating to their business that we would want to be notified of. Similarly, in relation to Section 11, where we talk about the service facilities, there might be little tweaks in their service facilities. Again, we don't need to be informed of everything. Significant change is what we are looking for. We appreciate that it is a judgment call, but we rely on the ASRs to exercise proper discretion and judgment. Obviously, if we have found that they are not exercising proper and reasonable judgment in this regard, then we would take action. We would have the ability to take action.
唔該。
好，繼續。係咪局方有啲？係，局方係。
啱啱審議咗呢個核准證券登記機構規則咧，我想大家去睇LN 14，就係2025年證券及期貨條例修訂附表8令。呢個係行政長官會同行政會議根據第571章下面制定嘅。因為我哋剛剛制定我哋審議咗呢個LN 16，就係呢個關於 ASR rules 入邊有一啲嘅決定咧，我哋將佢係擺咗落去，係一個證券及期貨事務上訴審裁處可以覆核嘅一啲嘅決定。咁我同事可以同大家講講，我哋擺咗嗰3個嘅決定係乜嘢。
OK， 好，可以。係朱浩副主。個咪未開，要開翻個咪。
得啦，
係啦，得啦。
關於嗰個2025證券及期貨條例修訂附表8令下邊呢，最主要嘅修訂就係附表8第2部第1分部78項之後呢，就加翻啱啱副秘書長講嘅3項嘅決定嘅。咁第一項呢，就係關於啱啱所講嗰個核准證券登記機構規則25(2)條下邊，就係證監會拒絕給予准許核准證券登記機構停止擔任該證券嘅核准證券登記機構嘅嗰個決定嚟嘅。咁第二，
冇事，可唔可以停一停？我想睇下簡慧敏議員係咪想問呢一部分，因為你係想問對上一部。
問翻頭先 Part 2嗰度。
OK， 唔好意思啊，因為啱啱見到撳咗掣，所以我哋一係啱啱嗰度講埋最尾嗰一部分先，好嘛？簡議員。
多謝你Part 2嗰度，即係而家係睇 B448嚇。B448嗰度即係需作出通知嘅變更咧。早前你有提及過呢度，即係 officer 佢就即係翻譯中文就高級人員啦。咁同埋咧就有senior employee 就高級僱員嘅咁樣啊。咁我諗呢度都係即係要清晰係指咩人啦，因為個責任喺個 ASR 嗰度去通知啦。C 咧就講係佢嗰個同呢個機構有聯繫嘅，喺呢個即係提供服務中即係 associate 嗰個概念啊。呢一度可唔可以都解釋一下，係唔係即係用翻即係都係頭先即係律政司提及嗰個571S 章嗰啲相關嘅定義咧？唔該。
邊位回答嚇
Maybe I try and answer first, Mr. Chairman. So the term officer and senior employee are both defined in the SFO. I will double check. My recollection is that associate is also defined, but we will double check. The idea of C is to mainly cover persons who are to whom an ASR might have outsourced any tasks.
但係主席 senior employee 咧，就頭先開始審議嘅時候，你都指出咗喺呢度亦都有定義嘅，係咪即係跟翻呢個條例就係101AAG 8嗰度？
Yes, thank you for that question. Yes, it is the definition in 101AA.
係， 即係唔同 officer 嘅係咪啊？即係或者喺呢度去演繹一下，即係同 officer 有咩唔同咧？除咗即係指剛才答咗話係其實跟 SFO 嘅定義啦咁樣，咁方便我哋去理解咧。其實高級僱員所指嘅同個高級人員事實上係即係指咩人嚇？
So officer would include persons like the director. The senior employee may or may not be a director depending on the particular ASR. In reality, depending on the size and scope of business of an ASR, the same person may be holding multiple roles, so which is fine. But in the case of a larger ASR, it's more likely that they will have different persons holding different roles. And so the idea is to make sure we cover all of them. So officer, the main one there is to include directors and I believe it's company secretaries, but I will double check.
好啊，主席。或者即係你會唔會喺個 ASR code 嗰度會再明確一啲咧？因為101 AAG 咧，其實個定義都係一啲描述式嘅嚇，即係話佢係負責係監管同埋管理嗰個 ASR 嘅咁。咁會唔會有一啲即係再明確少少喺個 ASR code 嗰度
？Thank you for that question. So the term officer is defined in the SFO itself, in the existing SFO, so Part 1 of Schedule 1. The ASR code does expand on what senior management is, because senior management may or may not actually be include the directors. So we have a separate definition for that as well, but the term senior management in the ASR code is used in the ASR code, and it's not really a concept used in the ASR rules. But for the definition of officer, it's in the SFO.
主席，我諗都唔係好掌握得到即係其實最初你都有問到，因為 senior employee 高級僱員咧係喺101 AAG 嗰度咧係用一個描述性嘅，即係話指申請人聘用的人，而該人就申請人執行監督或管理職能。執行監督或管理職能咧可以好闊嘅，即係可能係佢包括係佢個 compliance officer 啊。包括可能係即係負責 risk 嘅 CRO 啊，各樣啊嚇，即係根本你呢度監管及或管理職能咧可以好闊嘅，會唔會係即係喺個 ASR code 度有多一啲嘅即係即係確定性？
證監會有冇啲咩其他再補充？
Thank you for that question. So we do have in the application form, we do set out key lines of business, and we expect a senior employee to head each of those. So perhaps that would address your concern. So it includes compliance, for example. It includes someone heading the finance. It includes someone heading the operations. So there are, if I remember correctly, there are 7 or 8 key lines of business. We can send those back to you subsequently.
好，唔該主席。
係，如果事後可以補充啲資料，咁可以協助大家了解進一步。睇下啱啱LN16呢個附表仲有冇其他跟進？冇嘅話就交翻俾局方去翻啱啱我哋啱啱開始嘅 LN8係咪啊？呢個唔係 LN14 ，sorry，LN14嚇。
係關於 LN14就係2025年證券及期貨條例修訂附表80嗰度。咁啱啱所提到啦，最主要就係喺證券及期貨條例附表8第2部第1分部第78項之後咧，加翻3個證監會喺相關核准證券登記機構會做嘅決定。咁第一個決定咧就係啱啱審核嘅核准證券登記機構規則。第25(2) 條下邊就係關於證監會拒絕給予准許核准證券登記機構停止擔任該證券嘅核准證券登記機構嘅決定。咁第二項決定呢，就係同一個 ASR rules 下邊嘅第29(1) 條，就係關於證監會嘅決定要求該核准證券登記機構咧委任具相關技能嘅人士，就某適用事宜咧作出報告並呈交相關報告嘅。咁第3項決定咧 都係同樣都係 ASR rules 嘅第23(3)B 條嘅。咁就係關於證監會咧就要求核准證券登記機構咧因證監會委任相關既定人士就相關嘅事宜作出嘅報告咧而招致嘅一啲費用同埋開支嘅決定嘅。咁呢3項決定咧，如果核准證券登記機構有不滿嘅話咧，係可以向證券及期貨事務上訴審裁處咧係作出上訴嘅。
OK， 可以繼續。
好。係。咁我哋就去到呢個2025年證券及期貨條例修訂附表5嘅公告。咁應該就係 LN 19。咁呢一條咧就最主要就係修訂翻證券及期貨條例下邊嘅附表5第2部分，關於證券交易嘅定義嘅。咁最主要咧就係喺羅馬數字細楷11A 段之後咧，就加翻一啲相關嘅豁免嘅。咁個豁免咧就係羅馬數字嘅11B 啦。咁最主要就講明核准證券登記機構咧係純粹提供或者訂明證券公開發售相關嘅任何服務咧，係唔屬於即係受規管證券交易嘅個範疇嘅。咁入邊咧都提供咗一啲詳細情況嘅，包括大家喺下邊咧就提供招股詳情啦、公開發售提述嘅文件、公開發售廣告邀請或文件啦，或者公開發售申請嘅任何方法嘅。咁大家 B 嗰度咧就講到明就係都可以包括埋接收處理確認有關嘅證券申請嘅。咁大家 C 咧就講到明嗰個核准證券登記機構咧係可以提供或運作任何電子平台俾人去作為提出證券申請嘅。咁呢3項咧就係證券交易嘅豁免項目嚟嘅。
OK， 可以繼續。
咁啊，請翻證監會同事講翻另外嗰兩個附屬法。
So thank you, Mr. Chairman. So turning then to LN 17, which is the Stock Market Listing Amendment Rules. So essentially, these amendments amend the existing Part 4 of the Stock Market Listing Rules to deal with the issuer's obligations when it lists or has listed. Currently, they are required to have an ASR. The amendments preserve that requirement to have an ASR. The amendment in Clause 2 basically preserves the existing definition of issuer for other parts of the SMLR and introduces a new definition of issuer for the purposes of Part 4, which is the operative part relating to ASRs. So the key requirement here is that an issuer, when it seeks to list, must have an ASR. And if at any point in time it ceases to have an ASR, its securities must be suspended from trading. The rationale for this is to ensure equal treatment between investors holding securities in their own name outside CCAS and those holding securities through CCAS. The other requirement is in Clause 15, which is the notification of change in securities registrar. So this clause essentially mirrors the clause in the ASR rule, which sets out the obligation of the ASR to notify the exchange and the commission if there's a change in the ASR. Effectively, the idea is to impose the obligation on notification on both the issuer and the ASR. So Clause 15 seeks to do that. So that's the SMLR. Turning then to LN 18, which is the OFC, the Open-Ended Fund Companies Amendment Rules. So these rules put in place a regime for open-ended fund companies, and as a result, they include various provisions which are quite similar to the CO provisions. The amendments here are amendments that tally with those or correspond with those that we have made to the CO under the 2021 Amendment Bill. So Clause 50, the amendment to Section 58 is to clarify that the shares and other interests in OFC shares which are prescribed securities, they are transferable in accordance with the Part 3 AA rules. Section 60 deals with the requirement for instrument of transfer, and this is amended so that transfers can be effected with either an instrument of transfer or a specified request. Similarly with Section 61, which refers to the lodging of an instrument of transfer, again, this is amended so that it refers to either an instrument of transfer or a specified request. The amendment to Section 62, again, is really just to delete the word "is lodged" and replace it with language that covers the specified request as well. The amendment to Section 67 is to the provision on the register.
我哋停一停，簡慧敏議員。
會是呢一部分咧，主席，我哋係咪要睇個標明文本咧？因為而家講緊嘅喺18號公告咧，就唔係就咁睇呢一份嚇。我諗可唔可以即係去引述嗰個標明文本嘅00幾頁咁樣嚇？
有冇一個其他方式係咪啊？即係有。即係你意思唔係淨係用翻即係 markup 嗰個版本係咪？要用翻個版係 OK。
本嗰個版本，因為頭先頭先即係17、16嗰啲冇問題，因為佢係全新嘅。但係去到呢度咧係修改個法例咧嚇，唔該係用翻個 markup。
Yeah, so I think I was looking at the markup version. I'm not quite sure where the concern is.
Sorry， 即係你係喺003、004喺邊一度啊？
我諗，如果我哋而家現時嗰個立法會官方網站睇翻嗰個會議嘅嗰個議程入邊咧，有會列出嚟。
只限委員參與嘅嗰啲markup。
呢度。應該係呢個早前咧係立法會秘書處用電郵有。發過俾
所以我就想去指向翻只限委員參與嗰啲嘅標明文本。
係。咁證監會有冇可唔可以即係
18條嘅邊一度？第18 ，sorry， 即係 LN 18第18號法律公告嘅邊一頁嘅標明？
或者喺markup 嗰個版本上邊咧，喺即係上角啊，喺呢度上角有個 number 嘅，你或者係。每次講嗰個條文嗰時候，你講翻上面個 number， 咁我諗啲委員就會容易啲。我諗大家都喺度睇緊同一份嗰個markup 嘅版本，只不過大家可能即係未，如果你可以講得仔細啲，即係乜嘢 number， 咁大家可能跟得比較容易啲。啱啱講錯咗，唔喺個網頁度嘅，因為呢個係淨係應該嗰啲 markup 版本係淨係俾委員參考嘅，所以或者證監會可以繼續，不過你講得仔細啲個 number 嚇，唔該。
OK， 得，唔該。Looking at Section 67, which is on page 0005 of the markup version. So in the CO, there was an equivalent provision on the Register of Holders, which is Section 627 of the CO. We added a note under that section to mention that for matters relating to the Register of Shareholders of an open-ended fund company, which are prescribed securities, see also Part 3A. So we've added an equivalent note to the OFC rules for consistency with the CO amendments. I should just mention again, perhaps, that all of the amendments in the OFC are amendments that have been made to the equivalent CO provision under the amendment ordinance. So the idea of the OFC companies amendment rules is really just to mirror those amendments, because the OFC companies rules to begin with adopted the CO provisions. Turning then to Section 70
或者等先，大家係咪揾到即係而家所指定嗰個條文啊？如果大家 OK 係咪啊？即係係啦，咁我諗之後陣間會繼續，你每一頁你講到邊一頁，你講翻上面個 number， 咁大家容易跟啲，好嘛？唔該。
Right. So turning then to Section 70, which is on page 0007. So this relates to the company's power to close the register of shareholders. So the current provision requires that the register not be the current provision provides that the register can be closed for a period not exceeding 30 days in total per year. So the amendment, which mirrors the amendment to the CO, is that for shares of an OFC which are not prescribed securities, the existing provision remains intact. And for shares which are prescribed securities, the number is now changed to the number that is specified in the Part 3 AA rules. And as members may recollect, when we looked at the Register of Members provision, we have set a 2-day limit per each closure. That's the end of LN 18.
好啦，講到呢度停一停，睇下委員仲有冇對於啱啱所提及有啲咩其他跟進？係江玉歡議員。
好快啫，我想有個 general question， 即係喺而家咧呢個 LN 18/2025嗰度咧，我都見到最尾喺page 6嗰度咧都有啲 note 嘅。我想請問今次咧放啲 note 上去，係咪都係第一次定係以前不嬲都有 note 㗎咧？
證監會。
Thank you for the question. Do you mean in the OFC rules?
Yes, open-ended fund companies 嗰個。
I apologize. I don't know if there are notes in the OFC companies, in the OFC rules, but the reason we put the note here is because we added a similar note to the corresponding provision in the CO, and so we felt it's appropriate or necessary to do the same for the OFC rules.
我覺得好有用，主席嚇，我覺得好有用。不過即係話，好似對上我哋第一次審第一條嘅時候，法律顧問都有講，即係如果今次係第一次放呢啲 note 或者 example 落去，都要搞清楚就係佢哋係冇 binding effect 㗎啦，即係話係咪？唔該。
OK， 係睇下仲簡維敏議員。
係主席，我呢個係一個即係一般性嘅嚇，譬如就算就住頭先 LN 16嚇，關於個 ASR rules 嗰度咧，咁我哋有提及咧就話，除咗嗰個即係fraud 嚇，有欺詐或者係即係偽造啊、銷毀文件喺呢個條例喺個規則度咧，直接係create 咗一個直接係有一個即係罪行啦。咁其他對於 ASR 嗰啲規管咧，就會依賴翻原來 SFO 或者原來嘅 regime 係點樣樣嚇。咁可唔可以俾我哋一個書面嘅回覆嚇？即係等我哋清楚咧喺個 ASR 個管理上邊咧嚇，因為裏邊對佢每一個 part 做咗一啲咁好嘅規定啦嚇，我嚟保障我哋成個即係 USM 機制落實咗之後，對於個 ASR 點樣進場啊，嗰啲進咗場又受咩規管咧？咁我哋想知道即係有一個回覆啊，或者等我哋一目了然一啲，知道點樣去管理佢。咁另外我記得我喺開始傾 policy 嘅時候咧，政策問題嘅時候都有問過嘅。如果現有嗰啲 ASR 咧，我哋係咪預計佢都係能夠進入到呢一個嘅機制嗰度去得到我哋核准咧？即係話 approval 係咪都攞到咧？咁如果有退出嘅時候咧，而家當局係咪同相關嘅而家嗰啲 registrar 嚇，即係做緊嘅嗰啲嘅登記機構咧係有聯繫，等佢可以有序去退出嘅咧咁嚇，唔該。
係證監會梁生。
問題多謝。第一個問題我哋可以俾翻個書面回覆，解釋翻我哋即係將來點規管嗰啲核准證券登記機構同埋啲要求係點咁，我會俾翻個書面回覆你。第二個問題咧就係其實唔係今日。我哋一直呢段時間咧都同現時提供緊證券登記服務嗰啲公司咧有個溝通嘅。咁其實佢哋大部分都準備緊申請做核准證券登記機構，但係個法例未批准啦，佢哋未可以即刻入紙申請咧。咁我哋同佢溝通緊。咁你個問題係好重要嘅，就係如果有一啲證券登記機構同我哋溝通嘅過程，我哋知道佢其實未必有意思參與將來無紙化個業務嘅時候咧，我哋會馬上要求佢通知相關嘅上市公司，等個上市公司可以決定咧係準備緊轉另一間核准證券登記公司。咁但係我可以講今日。根據我哋個溝通咧，其實大嗰啲同埋一啲中型嗰啲，其實佢哋都好願意繼續提供個服務啊。
好，唔該。
主席。
係局方何生。
補充一句多謝主席。其實法律顧問咧都睇得好早都睇到呢個 issue 嘅。喺佢法律顧問係喺 2月28號俾政府當局嘅信入邊咧，佢都有提過就話，譬如違反咗呢個 LN16入邊嘅即係法律公告嗰啲規定嘅後果，咁我哋有一啲初步嘅回應俾咗。咁梁生剛才講，我哋會再翻去睇下，如果有需要，我哋再喺嗰度再提供一啲補充資料，好嘛？
係，我諗除咗啱啱簡議員所提嘅內容之外咧，今日所討論嘅就即係好似今日一開始會議咁樣啦，即係有啲書面嘢咧，都麻煩你通過秘書處補翻一啲跟進嘅資料俾翻我哋。
可以，我哋會同秘書處夾佢哋俾一個清單我哋就會翻去準備我哋嘅資料嚇。
OK， 唔該晒。咁好啦，如果冇其他問題嘅話呢，咁請各位委員留意呢6項附屬法例嘅審議期已經延展至2025年4月16日嘅立法會會議。我本人呢會喺3月28日向內務委員會呢作出口頭報告。就修訂附屬法例作出預告嘅期限為2025年嘅4月9日嘅。咁睇下議程第二係其他事項，睇下有冇其他事項。冇其他事項呢，咁我就宣布會議結束。多謝各位。